Welcome to WIPO Arbitration and Mediation Matters, the WIPO Arbitration and Mediation Center's podcast on intellectual property and innovation disputes. My name is Celine, and thank you for listening, as this podcast aims to provide practitioners a deeper understanding of the use of alternative dispute resolution mechanisms, for example, mediation and arbitration, for such disputes. Today, we are delighted to have with us Ida Palombella and Chiara Accornero to share their views on using alternative dispute resolution for disputes in the fashion and luxury industry. Ida is a partner at Deloitte Legal in Milan and is responsible for intellectual property and information technology services, as well as the fashion and luxury sector. She has extensive experience gained in prestigious international firms in the fields of intellectual property and technology in and out of court, as well as in the management of IP aspects of extraordinary transactions. Chiara Accornero joined the WIPO Arbitration and Mediation Center here in Geneva in 2016 and was the center's representative at Maxwell Chambers in Singapore from 2017 until mid-2021. Thank you both for joining us today. Chiara, if you would, please take us away.
Thank you, Celine, for the kind introduction. So in the last few years, WIPO has seen a marked increase in mediation arbitration cases, with businesses really looking for alternatives to core litigation, especially in cross-border disputes. And actually, a number of these cases are in the fashion and luxury industries. For example, in relation to IP, so licenses, infringements, royalty payments, but also in relation to contractual obligations. So for example, in the area of advertising, image rights, franchising, distribution, but also manufacturing, product development, and marketing. Ida, is there any particular type of disputes in the area of fashion and luxury that you see the most?
Well, fashion and luxury industry has faced several challenges in the last few years and have completely changed the ways it operates on the market. Particularly during the pandemic, the vast majority of disputes we have seen are in the fields of distribution, like online distribution, mostly through e-commerce and the use of social network. There have been a dramatic increase in this kind of dispute. Then, of course, we have the big classic, like trademark infringement and dispute-related IP rights on the infringement of IP rights, both in contractual and in non-contractual environment. Then we also have to mention the new frontier. We are foreseeing that probably in the future we will see an exponential increase in disputes also in IP rights in the metaverse. Any new in the so-called new internet, we are already aware of the very first legal actions started by Hermes or Nike for the alleged infringement of their IP rights in creating NFTs. And this, I think, will be the next step ahead of litigation in the fashion industry.
Thank you, Ida. That actually reflects quite well our experience. So we also see that very often parties to fashion disputes are from different jurisdictions or they are involved in cross-border transactions, and even more now with the digitalization of fashion. We also see disputes where time is of the essence for parties, and this is because the market in fashion evolves very, very quickly. The seasons are very short and the product cycles are also very fast. And also, we see the disputes in the area of fashion do require a certain sector knowledge and also the expertise, the experience to recognize and understand the legal issues of the industry. Confidentiality is also a very important consideration for the parties. And this is, of course, when confidential information is at stake, but also for reputational reasons. Ida, do you find that disputes in the fashion industry maybe have some specific characteristics? So, for example, what are fashion brands, fashion companies looking for when they're managing disputes?
Yeah, the list you made on the main characteristics of the ADR, it's perfectly fit the needs of the fashion industry. First of all, most of the disputes are international, are between or among parties located in different countries, different jurisdictions. So the international profile is very hard of this industry. And most of the litigation are cross-border. So flexible tool like arbitration, mediation can be much easier to handle compared to the tribunals and courts that are located in a specific country. Then confidentiality. Confidentiality for two reasons, as you mentioned. One is the contents of the disputes, the information that are potentially disclosed that form part of the dispute, but confidentiality related to the dispute in itself, because reputation is particularly relevant in this industry. And so, whereas a litigation in court can easily be disclosed on the press and it can some way affect the reputation of a brand, this kind of dispute resolution means are kept confidential, and this preserves what is really very, very important for brands. Really, in my experience, one of the topics that are raised most frequently when you have to choose what kind of litigation start. And then, of course, expertise. So the knowledge of the industry, the in-depth knowledge of the industry is very, very important. Also, when you are choosing the forum in the jurisdiction clause in drafting an agreement, when you're negotiating an agreement, even when you go for the choice of courts, you tend to choose in this kind of dispute the courts that are more expert in the industry. For instance, in Italy, you tend to choose the Court of Milan, who has, of course, the largest experience. But the ADR, like the one WIPO provides, have this great plus that you can build a panel made by experts. And this, I think, it's another big opportunity for brands.
No, absolutely. We see that as well. And in fact, in our mediation arbitration cases, we also often see mediation as a first step in a multi-tier dispute resolution process, so either before arbitration or before litigation. And based on our experience, we really encourage having this first mediation step. And this is because most cases settle in the mediation phase, really about 70%, and in fact last year 78%, so close to 80%. But even in those few cases where parties do not reach a full settlement in the mediation phase, usually through the mediation they manage to resolve some of the issues at stake, so that the subsequent dispute resolution process, whether arbitration or court litigation, is actually faster. And to also help parties refer their disputes to WIPO mediation arbitration, we have model clauses that parties can use in different languages. But we're also available for any consultation in case you want to draft a specific clause or a submission agreement. Anita, are there any other factors that fashion brands, fashion companies should consider when using mediation and arbitration?
Yeah, definitely agree with you. It's exactly as you described, this kind of flexibility. You know, I always said when you have a creative industry and creative brands, your client is a creative, you have to be created also in the use of laws and the use of tools to solve disputes. And so the more you have a flexible way to solve the dispute, the better, specifically for this kind of clients. And as you mentioned, any possible means that you can use in order to preserve the business relationship is fundamental. For instance, we know that mediation is more commonly used in common law countries that are more flexible, actually, whereas civil law countries like Italy, when you go for litigation in court, you are bound by strict rules of procedures. And we have to really push a little bit more, I think, in our jurisdictions like Italy, but also France, Germany, jurisdictions that are based on civil codes, in order to promote a little bit more the use of mediation. That is an alternative way that, particularly when you have a business relationship between the parties, that really may want to go on with their business after the litigation is closed, then mediation is really a fantastic way to explore, a fantastic tool that we should really, really promote more and more. And I think that if we are able to explain how flexible it is and how useful and functional it is, particularly in order to preserve the business relationship, what exactly you were describing, I think it will be more and more common to see this kind of alternative way of solving disputes before avoiding to go to court and have costs and have a situation of uncertainty that goes on for months and sometimes for years, which is a big disruption for business.
Absolutely. We see that as well. We see in particular that mediation, arbitration can be attractive strategies for fashion luxury companies to control disputes from a global perspective. And this is really because of their flexibility. So, for example, parties can choose someone with a specific expertise in the industry, but also parties can structure the procedure as they like. So, for example, in terms of timelines. Parties can also use the WIPO online tools, for example, video conferencing services, and these are also offered for free by WIPO and have been increasingly used in recent cases, with a very positive feedback from both the parties and the mediators. Another advantage of mediation arbitration, in particular of mediation, is that parties can really explore remedies that are not always available in court litigation. So, for example, a declaration of non-performance or infringement of rights, or even the delivery of a specific good or the conclusion of new contracts. And also we see that through mediation, parties can go beyond their strict legal rights and obligations, and they can really find solutions that suit their business interests. So, for example, we've seen mediations where parties were able to renegotiate their contractual relationship or even commence one in the first place. And this is really another advantage of mediation, which not only resolves the dispute, but also maintains and even begins business relationships. Ida, how do you think that mediation and arbitration can help fashion brands managing their dispute?
Well, I see what we have described in our chat today is every aspect is relevant. Of course, whenever you think ahead of potential dispute, you are entering in a better agreement. So model clauses that you mentioned, for instance, are a perfect way to provide in advance a tool to the parties that whenever, unfortunately, litigation will arise, they will already have set rules that can be applied in terms of law applying to the subject matter of the dispute, the seat of the dispute, the language, and possibly the use of tools like WIPO provides in order for them to also have a panel made by experts. So the main rule, in my opinion, is to think ahead, have awareness and knowledge of the tool that institutions like WIPO put at disposal of companies in order to find the better possible way to sort out this kind of claims, this kind of disputes. And for all the reasons we have described today, I think that this kind of means will be more and more in use in the fashion industry. So from single procedure, international procedure, cost, speedy expertise, confidentiality, preserving the business relationship. I think the list is really long, and I really don't see any way that company will not want to use this kind of means. They have to get better knowledge. So our main task as institution in your case, as lawyers, in my case, as professional in this industry, is to make brands aware of the big advantages of this kind of means to solve disputes.
Thank you, Ida. We actually also often see mediation and arbitration used even where there is no contractual arrangement between the parties. So, for example, in the case of an infringement or pending court litigation. And for example, for this, we call it the unilateral request for mediation. So this is a very short document, a very short form that a party involved in a dispute, for example, in an infringement, can submit to us, to WIPO, in order to propose mediation to the other party. And the filing is free of charge. And once we receive the request, we can contact the other party and assist the other party considering the mediation option. Ida, is this something that you see as well? Do you think that mediation and arbitration could also be useful in infringement cases or pending court litigation?
We are starting to see them. Of course, it's much difficult because these are even more controversial, because when you have an agreement, the parties are more keen in preserving the business relationship. They want to cooperate maybe more in order to avoid disruption of their business, whereas when they are third parties with no contractual link among them, no contractual arrangement, of course, it's somewhat more difficult, but sometimes we see it, and it also depends on the local procedure. Sometimes pending court litigation allows to solve at least some issues by mediation, by alternative dispute resolution while the litigation is pending. This is not possible in other jurisdictions. But again, what we need to do is make the parties aware that they have this possibility, and this can greatly help. Also, when there is a litigation between third parties that have no business in place, but in any event, cost and uncertainty that is caused by litigation is something that, of course, may damage business anyway. And so also to have access to this alternative dispute resolution means to minimize the damage that litigation and dispute can bring.
Thank you, Ida and Chiara, for joining us today.
Thank you, Celine, for having us.
Thank you. It was very interesting to understand that from an institutional point of view, the key questions are the same, and what we see in practice, what WIPO is expecting to see in the market. So total coincidence of the main aspect of this kind of topic.
For more information on WIPO's alternative dispute resolution services, you may visit the WIPO Center's website or follow us on LinkedIn.